Welcome back to the Military Justice Podcast. Today we are going to examine the case of Captain Kristopher M. Dolehanty, United States Air Force, a former member of the 78th Operation Medical Readiness Squadron at Robins Air Force Base, Georgia. Let's dive in. Captain Dolehanty enlisted in the Air Force in January 2006. He attained the rank of Master Sergeant and then commissioned after being accepted to the Inter-Service Physicians Program. His accomplishment was celebrated on the Maelstrom Facebook page. In his 17 years of service, he deployed 3 times. After his deployment in 2011, he began having negative symptoms diagnosed later as post-traumatic stress disorder. As a result, he struggled with alcohol use disorder, anxiety, and depression, which influenced the misconduct resulting in the convicted offenses. Captain Dolehanty's sentence adjudged the 10th of May 2023 by General Court-Martial. Sentence entered by military judge on the 22nd of June 2023. Dismissal, confinement for 59 days, and a reprimand. In accordance with Captain Dolehanty's pleas and pursuant to a plea agreement, a general court-martial, he was convicted of 1 specification of flight from apprehension, in violation of Article 87A, and 1 specification of willfully disobeying a lawful command of a superior officer, in violation of Article 90, Uniform Code of Military Justice. Dolehanty was charged with 2 specifications alleging sexual assault without consent, 2 specifications alleging sexual assault causing bodily harm, 1 specification alleging assault consummated by a battery, 3 specifications alleging domestic violence against a spouse, 1 specification alleging conduct unbecoming an officer, and 1 specification alleging indecent conduct in violation of Articles 120, 128, 128B, 133, and 134 of the Uniform Code of Military Justice. These charges were dismissed with prejudice, consistent with the terms of his plea agreement. Lieutenant General Stacy Hawkins, commander of the Air Force Sustainment Center, reprimanded him for his behavior on the 2nd of June 2023 as a member of the Air Force. He stated, "As a member of the United States Air Force, you are afforded a certain level of trust and privilege by the community you serve. Your misconduct damaged the trust placed in you and degrades the trust placed in other service members. As an airman and officer, you are expected to be upstanding and of good moral character. You have failed to meet these expectations." Additionally, the military judge sentenced him to a dismissal, confinement for 59 days, and a reprimand. The convening authority took no action on the findings or sentence and denied appellant's request for waiver of all automatic forfeitures. Now, why are we reviewing this case? Well, Kristopher chose to appeal the case. He raised 2 issues. 1. Whether a plea agreement requiring dismissal for low-level offenses renders the sentencing procedure an empty ritual and violates public policy. And 2. Whether his sentence is inappropriately severe. Another way to state it is, 1. The crimes for which he was convicted were not severe enough to warrant a dismissal. 2. Whether his sentence is too harsh. Regarding the first issue, he argues, including a mandatory dismissal as a plea term for a case involving low-level offenses is contrary to public policy and thus should not be enforced. He further argues, requiring a mandatory minimum dismissal for low-level offenses prevents the military judge from being able to appropriately craft a sentence and disrupts their ability to ensure the ultimate sentence is sufficient but not greater than necessary. The appeal court disagrees with the following points. 1. It did not deprive him of his opportunity to obtain a fair and just sentence. 2. While the military judge had discretion in determining other aspects of an appropriate sentence, in that the plea agreement, there was no minimum sentence to confinement was mandatory. Therefore, no relief was given for this first issue. Regarding the second issue, he argues, taking into consideration the original charges, the facts surrounding the charged offenses, his life experiences, and his acceptance of complete responsibility, his sentence to a dismissal is inappropriately severe. This appeal court disagrees again. They argue that though he had a substance use disorder and multiple mental health conditions, and yet he served honorably for approximately 17 years, He was selected for a prestigious and competitive officer program, and he successfully transitioned from the enlisted ranks to becoming an officer. Additionally, he was under a no-contact order because he was under investigation for allegedly harassing his ex-wife and for committing acts of violence against his stepson. Yet he chose to attend his stepson's school event, putting him in contact with his ex-wife in violation of said order. Although he knew he was violating the order, he chose to remain at the event. While he was under apprehension with agents, he disregarded instructions to remain in the interview room while being questioned. While trying to leave OSI, and while being told by the agents that he was not free to leave, Dolehanty physically pulled away from the agents and left the building. Agents had to physically restrain him fleeing outside the building to maintain control of the situation. The court also cites alleged sexual abuse to his ex-wife, physical abuse to his stepson, mistreating an enlisted airman and assaulting her, texting a female subordinate inappropriately, making false statements regarding his licensing, alcohol and drug abuse, and use of his rank and position to interfere in an investigation. The court reminds Dolehanty he did not offer any character statements or other evidence in mitigation. Ultimately, based on individualized consideration of Dolehanty, his character, his service record, and the nature and seriousness of the offenses with which he was convicted, they found the sentence, including the dismissal, was not inappropriately severe. Therefore, the findings and sentence are affirmed. When an appellate court affirms an appeal, it means that the appellate court has determined that the lower court's decision was correct and should stand. What do you think about the results?
If you enjoyed this video, like it. Hit the notification bell for all updates.